Thank you, members, for dashing between meetings. We have a quorum now. So this is the panel on administration of justice and legal services. Let's give a start. Information papers issued since the last meeting. We have a paper on the subsidiary legislation related to privileges and immunities conferred on consular posts, which is about the granting of privileges and immunities by the Central People's Government to specific career consular posts established in the Hong Kong SAR, and also the progress of the administration's preparation of the subsidiary legislation relating to the P&Is conferred on the above consular posts. The subsidiary legislation is proposed to be tabled in LegCo in May 2015 for negative vetting. Item for discussion at the next meeting. CB-4.493/1415/01 and (02). List of outstanding items for discussion and also list of follow-up actions. The next regular meeting of the AJLS panel will be scheduled for 4:30 p.m. the 23rd of March 2015, Monday. The administration has proposed to discuss the provisional legal aid and assignments of lawyers to legally aid persons by the Legal Aid Department. And the administration has indicated that if members think there is a need to discuss the information paper mentioned just now, which is the subsidiary legislation relating to P&Is conferred on consular posts, the administration is prepared to brief members on the paper at the next regular meeting of the panel. So do we agree to the arrangement? So we agree to the items to be discussed. Okay. Next, let me remind members that in accordance with Rule 83A of the Rules of Procedure, if members have any direct or indirect pecuniary interest in relating to items discussed at today's meeting, you should disclose the nature of the interest before you speak. Now, the draft Court Procedural Rules for the Competition Tribunal has been issued and circulated to members, and that is the CB-4.493/1415/03 from the Judiciary Administration, a paper entitled Proposed Subsidiary Legislation on the Procedures to be adopted by the Tribunal, adopted by the Competition Tribunal, and also a submission from the Hong Kong Bar Association, English version only, CB-519/1415/01. The since enactment of the competition ordinance, the administration have been working on the setting up of the Competition Tribunal, and the relevant provisions have come into effect on the 1st of August 2013. And I'll now invite Assistant Judiciary Administrator Ms. Wendy Zhang to brief members on the relevant paper. Ms. Zhang will give a start and then allow members to ask questions. Thank you, Chair. I'll brief members today on the 4 sets of subsidiary legislation relating on the procedures to be adopted by the Competition Tribunal. As Madam Chair put it, since 2012, after enactment of the competition ordinance, the administration and the judiciary have been working on the phased implementation of the ordinance. One of the key tasks for the judiciary is to set up the Competition Tribunal, or tribunal in short. This is a superior court of record established under the CO to adjudicate on the following matters: enforcement cases brought by the Competition Commission, follow-on private actions, alleged contravention of a conduct rule as a defense raised in proceedings before the CFI, as well as certain determinations on the Communications Authority. The provisions relating to the tribunal commenced on the 1st of August 2013. The President and Deputy President of the tribunal were also appointed. I'll now come to talk about the proposed rules. As other courts in Hong Kong, there is a need for a set of rules to be drafted for the tribunal to conduct its proceedings accordingly. And the tribunal, as provided by the CO, may decide on its own procedures and may, as far as it thinks fit, follow the practice and procedure of the CSI in the exercise of its civil jurisdiction. And in conducting the relevant proceedings, the tribunal is to be as informal as possible so as to attain fairness and justice. And having drawn reference to the rules of High Court, we have prepared 4 sets of subsidiary legislation. The first set is Competition Tribunal rules. The second, the rules of the High Court's amendments. And the third set, Competition Tribunal fee rules. And the fourth set, Competition Tribunal suitors fund rules. Well, Ms. Zhang, actually, we'd like to hear more details from you because not many members are from the legal sector. And I understand that previously on this matter, members showed great interest. So please give us more details so that we could understand the issues better. Don't just briefly walk us through the paper. Do get into the details because some members were not here in the past, and please tell us how you can address the problems so that after hearing your presentation, we can really have a better understanding of the situation now. Well, I welcome questions from members if you want more details. So may I be a bit more long-winded? I'll come to talk about Annex A, about the Competition Tribunal rules, CTR. Now, in formulating the CTR, we first of all made reference to the rules of High Court. We've also drawn reference to the rules and procedures of other courts and tribunals in the judiciary using informal rules, such as the Land Tribunal rules. We've also taken into account rules and practices similar applicable to similar proceedings in other common law jurisdictions, such as the UK and Canada. And we also paid visits to UK and Australia in looking at and also the EU in the handling of the relevant matters by their tribunals. Now, like I said briefly just now, the tribunal will be dealing with cases of various types, and we believe that there should be different approaches to different categories of cases. So there are 6 parts to proceeding. For Part 1 and 2, there are general provisions which are applicable to all proceedings before the tribunal. As for the next part, it has to do with specific rules applicable to reviews of the Commission's reviewable determinations. And we see that in handling such reviews, the nature of such reviews are similar to judicial reviews in the CFI. So we've also drawn reference to the rules applicable in the CFI of the High Court in judicial review cases. And the fourth part, which is very important, contains specific rules applicable to the enforcement of commitments, enforcement applications. Now, in the CO, there are rules such as the first conduct rule and second conduct rule, and if necessary, Mr. Grover can supplement on what these rules are about. But I believe these are the most important cases to be tackled by the tribunal, and they may also involve companies in the same sector. For example, if supermarket A is alleged to have breached the first conduct rule, then we believe that other supermarkets, not only supermarket A, will be interested in the determination. Because if the tribunal finds that supermarket A in breach of the first conduct rule, that means in future other supermarkets B, C, D will be banned from adopting the same practices. So these cases will be cases of major public concern. Next part. If the tribunal finds that such an act is in breach of the CO, then the next part are specific rules applicable to follow-on actions for damages. For example, if the supermarket is found to be in breach of CO, then the other small shop next to it may take follow-on action and claim damages for the business loss as a result of that act. Now, next part relates to proceedings transferred from the CFI. There are some provisions in the CI, in the CO, that under some circumstances, in all fairness, some cases can be referred to the tribunal for further proceedings. So it means those cases which have the hearing of which have started and subsequently transferred to the tribunal. Now, I've covered different types of cases, and we amended the ordinance last year in light of members' concerns, and in designing the relevant rules, we have taken into account the views expressed by members then, or even before that, in 2012, when we were still preparing the competition bill, we also tried to incorporate views expressed then to allay members' concerns. So now, in drafting the rules, we have tried to adopt the practice under the rules of High Court for the purpose of the tribunal, because the rules are familiar to everyone, and yet we need to strike a balance between adopting the same or familiar procedures and making the procedures more informal. So that is why we have adopted this approach. As members may see in Annex A, we have included some forms instead of writs, so that information can be set out very clearly in a table format, so that even small companies can fill in the forms very easily. The second type of cases, the feature is that most of them are commercial cases. When we visited the EU and the Australia courts, we found that there are cases that must be dealt with quite urgently. So in the tribunal, we'll also take a proactive case management approach to ensure that cases can be dealt with expeditiously if needed, so as not to affect economic activities. Thirdly, as members raise the issue time and again, that it is important to save legal costs and time of applicants. So we have 3 suggestions.
Under certain circumstances, we can say that the RHC doesn't apply to certain cases. Say, for example, small sums of money are involved, or simple cases. And then when it comes to the production of evidence, first of all, the directives from the tribunal have to be listened to first, so as to avoid unnecessary costs. And then in appropriate cases, relevant cases can be consolidated. Say, for example, the defendant is the same in a number of cases, or they have the same matter put before the court. So I've just briefed you on Annex A, which is the first set of rules. Now I come to Annex B, and that's about the related amendments to the rules of the High Court. It's relatively speaking technical, so as to achieve 2 purposes. First of all, as I've mentioned, under CO, cases can be transferred from the Court of First Instance to the CT, and it can be booked the other way round as well. That is, cases can be transferred from the tribunal to the CFI. So there is this matter of jurisdiction, and therefore we have to have this amendment accommodated in RHC. Therefore, we are moving amendments so as to facilitate the transfer of cases. And secondly, if the tribunal comes up with a decision, if it is to be appealed against, then it will go to the appeal court, and therefore we have a similar procedure. We have made reference to the arrangements as to how to deal with the application for leave to appeal to the Court of Appeal. And then thirdly, we have the Competition Tribunal fees rules. As in other CFI cases, we have to impose a charge, say, for example, filing of originating documents. In the future, the CT will mainly be working like the CFI, and therefore we're saying that there should be a set of fees, and they would be same as the CFI as much as possible. And then Annex D, and that's in relation to the suitors funds rules. I think members may recall that in November last year, we passed the Competition Amendment Bill 2014. We have already included this power to handle the suitors' funds. The details are set out in the rules. Say, for example, when interest can be paid to the suitor, and then when the tribunal is to take care of the money temporarily, we need to come up with an annual financial statement. So it is a matter of financial management. This is very similar to the operation of the CFI, and therefore when we prepared the CT suitors funds rules, we made reference to the RHC. If I may summarize briefly, and if you want more details, I can certainly elaborate. In the past year, we have already had very detailed discussion, consultation with the various stakeholders, like the Hong Kong Bar Association, the Law Society of Hong Kong, the Competition and the Communications Authority. We had meetings with them to look at the draft rules in great details. We have already taken on board their views, and they now generally support our amendments. Maybe I would like to pause here, and then members may want to ask questions. Thank you. Thank you very much, Ms. Zhang. Thank you, Ms. Wendy Zhang, Assistant JA. Now it is time for members to ask questions. First of all, Mr. Albert Ho. We have two panel meetings going on, so it is difficult for members to rush between two meetings. Now, if we've only got Albert Ho wishing to ask questions, I'll be more relaxed in terms of time management. So if other members would like to ask questions, please raise your hand. Albert Ho. In fact, Madam Chair, I didn't have time to read the rules in great details. Well, there will be a legislative process, so we can have the details at that time. Now, I just want to ask a simple question. A lot will be harmonized with the CFI, so why don't you highlight the differences rather than the similarities? Yes, please be more detailed. Later on, I'll have some follow-up. Yes, I will give an answer, but since I am a layman, so maybe I can defer to my colleague lawyers as well. Well, say for example, in the principal ordinance, mention is made that the tribunal will not be bound by the rules of evidence. We are not bound by the rules of evidence. In a moment, I can invite the DOJ colleagues to elaborate. In other words, the tribunal won't be bound by the rules of evidence. Correct. In other words, they can have hearsay evidence. Another major difference is that when it comes to the handling of confidential information, we will put in more efforts. I hope members would understand that for the tribunal, it will be handling commercial cases, and there may also be leniency agreements. In other words, if a person is to blow the whistle, so to speak, he might have broken the law, but then he could have reached an agreement with the Competition Commission so as to get something like a leniency agreement. We have to be very sensitive and careful about such, so we have some rules about the confidential information. So this is more refined when compared with the CFI. We have already taken into account the needs of the tribunal. Say, for example, for the discovery of documents, the tribunal may ask for certain documents to be produced. Now, if the commission comes up and asks for a leniency agreement, and if certain things cannot be submitted, then maybe the case will be justified, and then under rules we will talk about the factors so that the commission can say that certain documents don't need to be submitted so as to enable the smooth functioning of the CO. Well, in overseas countries, we understand that in many cases, there is a need to have such an arrangement so as to cater for reporting on non-competition or anti-competition scenarios. And then we may have two companies having an action in the court, and then other companies may want to become an interested party. Among them, they don't want to share certain information, though the information can be given to the tribunal. So we have the confidentiality ring. In other words, documents sent to the tribunal may be subject to an application. Say, for example, company A may say that it's a sensitive piece of information concerning market share. The information can be shown to the tribunal, but not to the competitors like company B and C, etc. So that particular point should be blocked out, redacted, and it is subject to application. And then the rules would accommodate such a scenario. And then the rules will say under what circumstances the tribunal can consider the factors and allow that information to be blocked. And then sometimes we go to details like certain things known to the lawyer but not to the client or the company. So we have to act very cautiously when it comes to the handling of confidential information. The tribunal has to be careful because in overseas countries' experience, it has always generated a lot of controversy. Company B may object to the application because this may affect the outcome, the final outcome of the case. And then thirdly, another difference, and that is the degree of intervention. Just now we talked about anti-competition cases, and then it won't just be the stakeholders who would be interested. Say, for example, there is a supermarket A has been taken to court by the Commission for breaching the CO. Now, the tribunal takes over the case, and then it may not just be of interest to supermarket A. This is because when the tribunal is to rule on the matter, saying that it is anti-competition, then supermarkets B and C would not be allowed to do something similar in the future. So we believe that it is a matter of public interest. In this case, there will be a formal procedure, and it's set out in the rules. That is, when we see this, then the registrar will have to put out a notice. We may have it in the newspaper or a notice we will put up in the court, so to invite anybody who is interested to become an interested party. So there can be a formal application to become an interested party, and of course they have to justify the application. When the case reaches the tribunal will consider the rationale, the justification to see whether the participation will take the form as an ordinary party or whether the interest is very narrow and only certain part will be open to him, or just a written submission will be accepted from this party or person. Yes, you find it in the RHC, but then it isn't as detailed as necessary in this case. If I may also elaborate a bit more on the matter. Now, for follow-on cases, say, for example, the tribunal may say that certain things are anti-competition, then private companies so affected can also bring up follow-on private actions. So very similar to what the CFI has been dealing with. But then in this case, we emphasize informality. Yes, in many areas we follow the RHC, but we want to make it flexible so that when it comes to case management, we can be positive and active. So since we need to act swiftly, for the sake of economic reasons, sometimes we will be having different procedures. So I've set out the major differences, but of course there will be many other finer details. Albert, any follow-up questions? I want to know whether the tribunal will have concurrent jurisdiction with the CFI. If so, how are you going to deal with it? Say, for example, damages. Will there be concurrent jurisdiction? If I may give a reply, and Mr. David Grover can supplement. In the principal ordinance, mention is already made about the following. The CT has primary jurisdiction, but then under specific circumstances, the CFI may also have some jurisdiction about competition.
Please.
Essentially, all actions involving a contravention of the conduct rules or raising of a contravention as a defence must be held.
Can you speak to the microphone a little bit closer? Yeah.
Essentially, all actions involving a contravention of the conduct rules, or the competition rules, or in which they are raised as a defence, must be transferred to the tribunal. The tribunal also has jurisdiction to hear matters which are same fact related.
How about adjudication on consequential damages? Would the CFI and the tribunal enjoy concurrent jurisdiction? Would there be cases where one party may seek to transfer the case from the tribunal to the court or vice versa? And on what principles would such an order of transfer be made? A little bit technical, I know, but sometimes
it may be transferred back to the CFI if the interests of justice require it, and it's the same fact-related matter. But the basic contraventions have to be dealt with by the tribunal.
Anything to supplement? Well, basically, in our design, the CT is a professional tribunal and specialized tribunal, and if possible, all cases related to competition ordinance will be dealt with by the tribunal. But like Mr. Grover said just now, from 113, 114, 115 of the CO, they set out under the circumstances where cases could be transferred back to the CFI. So for follow-on private actions, if they are related to the CO, we believe that the starting point will be the CT, unless for some other special reasons. Any more questions? I don't know whether these cases may involve overseas evidence and witnesses, etc., because things have become globalized. I don't know whether there will be some form of international element. You're very correct. This is actually quite common. We have anticipated that in handling such cases, even if an international or multinational company is not involved, that a company itself may have other branches overseas. So when it comes to transferring cases to other jurisdictions, we also have the relevant provisions. The court's leave will have to be applied for. And in our design, we also have televised links. Of course, we don't always want evidence to or witnesses to come to Hong Kong. But in order to handle such cases effectively, in the design of the court proceedings, operationally, we have taken into account the fact that overseas witnesses may need to give evidence. So video conferencing may be used in taking evidence. Yes, possible. Of course, we encourage the witness to come personally, but that may have an implication on the costs, and we'll try to facilitate court proceedings as far as possible. Another point on costs. I recall there's suitors fund. Has it to do with legal costs? Now, about the suitors funds. For various reasons, funds may have to be deposited into tribunal, maybe security deposit, or maybe as a form of penalty. The funds will have to be deposited temporarily into the tribunal on conclusion of the proceeding. It may be given back to the claimant as a security for costs, as you said, but this is quite common for courts. But this is a new court, and we need to set up new rules for the suitors funds. But in terms of legal costs, the tribunal acts in a way similar to the courts, so that the winning party will get the costs. Is that right? And then the tribunal can also tax the costs. Is that right? Let me talk about the technical details. In our design, in Annex A, Part 4 says the following. Well, unless otherwise stipulated in the in Annex 4, the RHC rules should apply. So that means there is no provision on costs in this Annex A, and the RHC shall apply to all proceedings in terms of costs. Well, I have a question too, Ms. Zhang. I'd like to pick up on the point you mentioned just now. Say for lands tribunal, minor lands disputes, as we understand, will be tried by the tribunal. For disputes over matters related to competition or the CO, what is the level of jurisdiction? I mean, must every case start at the Competition Tribunal? What about cases involving larger amounts? Will the case be heard by the CFI at the outset, or what? Secondly, just now you mentioned in terms of the rules of evidence, you will accept, the tribunal will accept hearsay evidence. I think we need more details. Under what circumstances will you follow strictly the rules of evidence? Or whether any departure may be allowed in the tribunal proceedings. Please give us more details, because all along you emphasized that you will follow the CFI's practices. And you also mentioned in terms of judicial reviews, the reviewable determinations will also be reviewed in a way similar to Order 53. So I mean, like normal judicial review cases, you need to meet some criteria before leave may be granted by the court. For example, you need to prove that you are affected, you're adversely affected. And also, there should be a meritorious case. So will these same criteria be applied? I have lots of other questions to ask, but please answer me these few points first. Thank you, Madam Chair. Now, the first question, whether there is any ceiling of amount involved. The answer is no. As long as the case involves competition ordinance, regardless of the amount involved, the Competition Tribunal will have primary jurisdiction. Can I first ask you a follow-up question now? Just now, there was a point raised about legal costs. If we go to the Lands Tribunal, sometimes the cost may be really cheap, $1,000, I recall, for possession of a flat. But if you go to solicitors' firms, they may charge you $10,000 or $20,000. But you can actually fill in a form and apply at the Lands Tribunal yourself. Well, at this tribunal, you mentioned that securities or costs will be involved, and the rules applicable to CFI will also be followed. Now, in terms of the consumption model, will the client be charged in an accrued manner, or say if a proceeding lasts for 10 days, 20 days, the legal costs involved will be much larger than a hearing of 1 or 2 days. So something for the prospective litigants. Yes, in other jurisdictions, in Part 4, for enforcement cases, that is, if a company is the subject of a complaint for breach of competition ordinance, in the main legislation, it provides that the penalty will be equivalent to the annual turnover or 3 years of turnover. So this is the experience we see. The larger corporations will therefore engage prestigious lawyers and counsel for litigation's purpose. So this is about commercial disputes. And the second type is, as I mentioned just now, say a very small store next to a supermarket, and that store suffers a loss as a result of the anti-competitive conduct of the supermarket. And these are rather smaller cases. And the company may not have to be legally represented in such proceedings. And there is also one exception. With leave of the tribunal, other parties may also represent the litigant in the proceedings. For example, the trade association or somebody very familiar with the trade may be a representative. So for these smaller companies, the concern of which may be about cost, in these smaller cases, we try to press down costs for them as much as possible. Let's say I am one of the smaller parties and I'm unable to be represented. So in the small claims tribunal, for example, both parties are prevented from having any legal representative. So will there be something similar for this tribunal? Say if one party is really well off and if the amount in dispute is not so great as to worth engaging a counsel, will you impose a ban on legal representation? No, we'll follow the CFI's rules in that both can be legally represented. But of course, the litigant may choose to represent himself or herself as an individual. If the litigant is a company, then the company director may act on behalf of the company. So it's not like the small claims tribunal. Right, both parties could still have a choice of whether to be legally represented. What we are concerned is those with weaker means, and does it mean that this tribunal will not be able to deal with the asymmetry in wealth in both parties, so that the less well-off will be put in a disadvantageous position? Even in a minor dispute, this problem cannot be avoided. Well, there are limits to what we can do. We try to be as flexible as possible in our rules. We understand that there are smaller companies or ordinary members of the public who may find legal costs a very heavy burden for them. So the tribunal may order streamlining certain procedure so as to cut costs, and different cases can also be consolidated. This is what we can do within our remit in cutting costs. But judging from past experience, usually these cases are very complex. Without legal representation, it would be quite difficult to for proceedings to be carried out. Now, in Part 2, 40, Section 40, in Annex A, frivolous or vexatious proceedings. So that's the same as that in JR. Say if you think your business is affected by the anti-competition conduct, then even for an ordinary member of the public, he or she can rely on this, because you say that the principles are similar to those for JR. And for JR, you need locus standi, you need to prove a meritorious case. And what about a competition tribunal? The same set of stringent criteria should apply. An ordinary member of the public should not take the case to a court to challenge the two corporations which, in his view, may be dominating the market.
Let me answer your question. I talked about the JR, and that applies to Part 3 of Annex 3. In other words, under the CO, the Commission may make certain orders, and then we say that they are reviewable. And that's it. And you can find it in Schedule 3 to the Principal Ordinance. So when I refer to the JR, they refer to this particular area. Say, for example, the Commission may ban certain people from doing certain things. Maybe Company A is prevented from doing certain things. Company A may then come up to say that it would like to review the determination of the Commission. And then we have to go through a motion like the JR. So to review the determination of the Commission. So is it administrative? You call it administrative or statutory. But then I was talking about procedurally, they would be similar. First of all, you need to ask for leave, and then you enter the procedures. So it is quite the same as what you were referring to. In most cases, we'll be having companies as the parties to the case. I think probably in follow-on private action, then individuals will be involved, like a consumer. Like consumer having bought a certain item, He thought he could have got it cheaper. Now he has got 10 cans of Coca-Cola. He thinks that he has overpaid. In theory, he may come to the tribunal, but there won't be too many. So probably it will be smaller companies being affected by large companies, and then they want to get damages, and then they will come to the tribunal. You talked about keeping the documents confidential. Well, we often come across such a scenario. Businesses will claim that their documents should be kept confidential. You said that sometimes some information may only be shown to the lawyer but not to his client. Just now you said that you have set out the details. Please elaborate. This is because when we had the inquiry into the case of Lehman Brothers, we talked about such principles. Many banks would like to keep information confidential. We had to make a decision as to whether they should be kept confidential. So sometimes it is even said that tribunal members should be given the information instead of having it blocked from the member. So maybe the information is simply shown to the decision-making member, but not shown to the other party, the opponent. You have talked about many provisions to that effect. Can you elaborate? First of all, discovery. As you have said, even the decision-maker of the tribunal cannot have access to such information. Please turn to Annex A, page 18. We have a particular rule. Please turn to Rule 24, page 17 and 18 of the English version. Rule 24(3), we have got 4 factors being listed here, which the tribunal may have to refer to. Chinese version, page 15, Rule 24(3). 4 factors have been listed here. First of all, the need to secure the furtherance of the purposes of the ordinance as a whole. We are mainly talking about the leniency agreements. B, whether the information contained in the document sought to be discovered or produced is confidential. C, the balance between the interests of the parties and other persons. And D, the extent to which the document sought to be discovered or produced is necessary for the fair disposal of the proceedings. In other words, now the tribunal president and the member will be making the decision. We'll try to minimize the scenario in which even they cannot have access to such information. So we have to hold it very, uphold it, and therefore point D is particularly important. That is, we have to make sure it is necessary for the fair disposal of the proceedings. And then please turn to Rule 37, page 24. Turn over the page, Rule 37(6). In considering an application under this rule, the tribunal must have regard to all the circumstances of the case, including the following. So we have this so-called confidentiality ring. First of all, we have to consider the public interest. Second, for any commercial information relating to an undertaking, the legitimate business interests of the undertaking. C, for any information relating to the private affairs of a natural person, the interests of the natural person. And D, which is important, the interests of justice. In other words, justice is given a lot of significance. Just now, I was trying to ask about the following case. We have the case Conway against Swimmer. That is, members were shown the information. the facts have to be considered. So maybe the information cannot be shown to the opponent, but then the adjudicator should be shown the information, and you need to have faith in the adjudicator. So would it be allowed, or do you have to show the information to your to the other party as well? So please tell us whether this scenario will be covered as well. Rule 37 would cover your concern. The President can see it, while all others will have no access. But then this is upon application and approval by the President of the tribunal. You talked about the first conduct rule and the second conduct rule, and you talk about the example of the supermarket. Can you not elaborate on this point? I think not everybody is on that particular bills committee for the competition bill. So please elaborate on the first conduct rule and the second conduct rule. I'm interested, so please give us more details. Yes, maybe Mr. Grover can answer this question.
Okay, the first conduct rule is essentially aimed at collusive behaviour which has an anti-competitive effect. So an agreement or concerted practice which has an anti-competitive effect may contravene. Now, agreement is extremely widely defined, and we shouldn't make the mistake of thinking it's a formal agreement. Even an understanding reached over dinner or lunch may constitute an agreement. So it essentially means if there's collusive behaviour of whatever form, which has an anti-competitive effect in Hong Kong, then it may contravene.
咁兩種行為守
We have two conduct rules. I want to know about the penalties. Are they very different?
你特登要將佢分
Since you have two different conduct rules. First conduct rule, second conduct rule.
點樣唔同呢
How different?
Sorry, I didn't mention the second conduct
I
rule.
have to hear you clearly, sorry.
I'm sorry,
Because it's, I can't hear you clearly. Yeah.
Okay.
I have to, because I really, you have to speak closer to the microphone. Yeah, can I speak?
The second conduct rule addresses abusive behaviour of undertakings with substantial market power.
Can you think? Okay. 咁你哋嗰兩個行為守則包唔包括
For the two conduct rules, I want to know whether they would cover the following thing. That is, we don't want to have collusive pricing. Would that be covered as well? Because we know that for oil prices, you know that there are lots of challenges and queries from the public. So I want to know whether they will be covered by the two conduct rules.
Behaviour which sets prices may contravene the first conduct rule. Excessive pricing by an undertaking supplying the market in fuel, for example, that has substantial market power may be abusive. That's a harder case to make. So if you have an undertaking which is aware that for some reason there is a great shortage of fuel, maybe there's some major emergency and they have substantial market power and they simply take advantage of the situation and put their price up by 10 times or something, that may be an abuse. Or another example might be if they are the supplier of a key component in a market which other manufacturers are dependent upon, if they withhold supply or price it at a level at which it's not competitive or not possible for downstream manufacturers to make a profit and stay in business, that may be it may be an abuse. Predatory pricing by an undertaking with substantial market power may arise by somebody not liking the look of a new entrant to the market, wanting to defend their market share, and deliberately pricing below cost in order to make it impossible for the new entrant to compete. These sorts of things are addressed by the second conduct rule.
即係合謀定價係咪即係
collusive pricing, would it be covered by first conduct rule? I just now referred to a case. So it would be first conduct rule.
係令到
For second conduct rule, does it mean that you try to prevent competitors from entering your field easily? That would be covered by the second conduct rule. Can I sort of simplify it in this way? Collusive pricing, easy.
To start with the first one, retail price maintenance, as it's generally known, is agreements, horizontal agreements, to control the price at which products are marketed. That is generally regarded as contrary to the equivalent of the first conduct rule in jurisdictions like the EU and the UK. The US takes a slightly different view of that. In terms, sorry, your second question was?
你兩個行為
You have got two conduct rules, right? What about oil prices? In the society, we have always challenged the oil companies, saying that there has been collusive pricing, but then you said that it's first conduct rule because there's collusion. Now, for second conduct rule, I think you mentioned towards the end of your speech that by making competitors difficult to enter the market.
New entrants cannot enter into the game. I would like you to give us some specific example in daily life. Can you elaborate what is classified as the second type of behavioral code?
Predatory pricing may be conduct engaged in by an undertaking with substantial market power or dominance in a market who sees a competitive threat, decides to cut its existing pricing level, which is presumably profitable, below cost. Of course, we can debate how you measure cost. Below cost with the intention of driving the competitor out of the market, because obviously cost is a major factor in consumer choice, and if a supplier will provide you with a substantially enough discount, you're likely to be either loyal to them or move to them. If that price is set at a level which is below your cost of production, then it's impossible for somebody else to compete with you.
Yeah, but in that case, they are also doing aversive effect to their own products, right? They lower the price to such an extent that actually other people, if using the same price, they can't survive.
Yes.
Then how about themselves?
Well,
I mean, they must apply to very big corporation then.
Generally, yes, you would need deep pockets to pursue that. The expectation is that once you've driven the competitor out of the market, you no longer have a competitor, so you can put the prices back up and recoup your losses.
Okay.
Okay, the third question. Yes. I'll let the member ask the question first. Collusive pricing is under the first conduct rule. Preventing others from entering the market, that's the second conduct rule. Collusive pricing means you set a price at a level agreed by all parties. So the only thing you could do is the only scenario you could do it is when the product that you're selling is sort of dominating the market. If you're talking about the second conduct rule, it's really difficult for you to really prevent competitors from entering the market, unless under the first conduct rule, you practice collusive pricing and set it at a level lower than the market price. before you can really do something about the second conduct rule, so that the pricing is too low for any competitor to enter the market.
Is aimed at unilateral conduct, not collusive conduct. So you have to have market power. And
yes, I understand it. 咁即係好似你油咁樣，你七姊妹壟斷咗個。
Well, just like oil companies, the 7 major oil companies collude in setting prices. Because we follow the Singapore model, we have no oil produced. We have no oil supply in Hong Kong. So the first conduct rule means that, first of all, you need to have, your product should have a dominatory control in the market. Otherwise, you can't do it, because the first conduct rule is separate from the second conduct rule. So let me give you a simple example. Under the first conduct rule, the oil companies now can say that in Singapore the prices have gone up or down so and so, but it's not related to what's happening here, because the companies have dominated the market. And the second thing is, because of their dominance, no other competitors can enter the market. So that means under the first conduct rule, they're able to continue to dominate the market. Otherwise, what's the difference between the first and the second conduct rule? Mr. Grover?
Following the question, really. That they are two different concepts. You don't necessarily need to be collusive in order to be in a position to, when in fact you don't need to be collusive in order to abuse a position of substantial market power. You have market power and therefore probably have some price-setting ability. So they're really two different issues. If you have all of the, or the majority of the outlets for petrol, for example,
yes.
Then there may be people who can source petrol at a lower price than you can, or an equivalent price than your price, and don't wish to make such a high margin, who may be able to supply at a lower price than you're prepared to. But the fact that you have most of the outlets means that people who, in practical terms, need to use your outlet will end up paying your price. It's only if you've got competitors around the corner from your outlets and therefore don't have enjoy substantial market power that you're going to feel the effect of competition. And what I perhaps should have started by saying is you must first of all define the market. It may be that in certain areas of Hong Kong you have substantial market power because you're the only supplier, and some products customers are simply not going to want to travel to purchase. Large ticket items you may travel to purchase, but to take a trivial example, if you wanted a can of diet soda, even if it's cheaper 300 or 400 yards down the beach, you're not going to want to walk there, because by the time you get there and have had your drink and walk back again, you will be thirsty again. So the convenient place may enjoy some market power. That's not necessarily abusive. Oil companies may or may not be able to supply below the prices that they are actually supplying. They obviously forward purchase, so it's not as simple as saying that the current oil price has fallen on world markets. The local wholesalers may have forward purchased some time ago. We can be cynical about that, but without actually examining the evidence, we don't know.
唔係，我舉個好簡單嘅例啊。
Well, just to give you a very simple example, collusive pricing, stage 1. Oil companies are dominating fuel supply in Hong Kong. They get their fuel from Singapore. So after collusive pricing, without government intervention, nobody can do anything about it. The government must intervene and check the pricing in Singapore and tell the oil companies to lower the price accordingly. That's an effort of their collusive pricing. So about the second conduct rule next. Now, if a competitor enters the market and is willing to supply oil at a price lower than theirs, then in order to phase out competition, these oil companies will collude on pricing again to lower their oil prices as much as possible to drive up competitors. And in fact, this has happened before.
做呢個汽油嘅時候咧，即係做呢個供氣嘅時候咧。
Now, when the China enterprises first started their businesses on gas supply in Hong Kong, the Hong Kong government gave concessions and allowed them to use certain sites at a very low premium and allowed them to use a very low price to compete with others in terms of gas supply or LPG for vehicles. And now they're able to get a share in the market. So it's related to the first conduct rule, though not the same. So after you've dominated the market, you can set the price at a very high level. And secondly, if collusive pricing doesn't work, if a competitor tries to get a share by a lower price, then, well, in fact, that's not a price lower than the market price because there is no market price, there's only the colluded price. So if a competitor sets it at a price lower than their colluded price to challenge the existing companies, and then they can collude to set pricing again to challenge them, to drive up competitors.
So, but they would, if they were collusive, they would contravene the first conduct rule, for which there are substantial penalties, potentially.
But as a matter of fact, it's what happened in Hong Kong at the moment.
But at the moment, we don't have a competition law. That's why we need it.
Well, so I ask you how this implementation of this rules or ordinance can help Hong Kong.
Well, first of all, it makes it clear that collusive pricing is serious misconduct and contravenes the first conduct rule. Secondly, in the absence of collusion, abusive pricing, abusing a substantial market power, may contravene the second conduct rule. There are financial penalties, which could amount to 3 years turnover in Hong Kong. And the tribunal has the ability to make any number of orders which are set out in Schedule 3. So there are a number of avenues to address that. But of course you have to have the evidence, you have to prove collusion, or in the case of the second conduct rule, you've got to define the market, you've got to show not only that an undertaking does have substantial market power, but that it has abused it. That's quite a different matter. An undertaking may achieve substantial market power simply by being very good at what it does. It may simply be the best.
Well, I think in having a dialogue with you here, I think the audience in front of a TV or any ordinary member of the public will not be like us. That is, now about the competition ordinance, competition commission, or the competition tribunal, or the rules, how can they address the unfair situation in Hong Kong now? How can you effectively tackle the problem?
Commission, indeed it is only the Commission that can bring proceedings, initiate proceedings before the tribunal.
Yes, certainly. But can you give some layman, some example for the laymen who just sit in front of their bloody TV set and understand?
Well, retail price maintenance is a common problem, and I think it's fairly, my impression, I may be wrong, but my impression is it's fairly prevalent in Hong Kong. If you go to buy a lot of electronic goods, although there might be free gifts and minor change, essentially the market price wherever you buy it will be the same. At least that's my experience. That may not in fact be the case. I've not seen any market data. Generally speaking, I've not seen any major discounting, and you will often so the mere fact that that is the case is something perhaps worth looking at. If we looked at the products supplied through supermarkets, we may or may not find that there's real price competition. We may or may not find that small shops who try to undercut the supermarkets or refuse supply by the wholesaler or manufacturer who is the only source of that product in Hong Kong. If they react to a discounter by saying, well, I'm sorry, if you're going to charge that price for it, rather than the normal higher price, we won't be able to supply you. Of course, the reality is the situation tends to be rather more subtle than that.
But it's not the same case. Talking about the monopolization on the supermarket market, because we need to rely heavily on Singapore, the refinery. So my question is that, well, okay, you are going to say that, okay, the supermarket wise. But it's not the case, because as a person like me, I can simply to go to the bank and get a loan to open supermarket to challenge welcome or...
Yes, so the barriers to entry are, at least in theory, not high, because it's not a regulated business. You don't need a license. You may find, however, that when you try to find premises which are suitable, the number of available premises may be quite limited. So that may be a barrier to entry. So, and something which restricts competition.
So when it comes to your supermarket example, under the first contact rule, you must get Park and Shop, get Welcome, and other supermarkets. You must find evidence of these supermarkets colluding, and there is none. No evidence you can find. Second, you must find evidence of them preventing competitors from entering the market. So by whatever means, by bribery, by threats, by giving hints or giving threats that the competitors should not could not enter this market. Unless you have this evidence, second conduct rule is meaningless.
If you're not stopping a third party from entering the market, then that's it. So for the first contact rule, if it is not met, then you can't have it under second contact rule. Let me follow this up. Please explain more clearly. I want to cite the example of supermarkets. I hope the public, the general public, can understand how to rely on the CO to deal with anti-competition acts. Let me ask the question. I think the questions are related. We've only got little time left. Now, for supermarkets, you know that we have larger supermarkets under the larger groups. Now, first of all, let's set aside the first contact rule. For the second contact rule, under the second contact rule, they lower the prices substantially. Many wet market stores have said that it's difficult for them to survive because they can't lower the prices as much as the supermarkets. As a result, gradually, many people will go to supermarkets to buy fish and other groceries. Supermarkets can lower the prices for a long time. For the wet market stores, they find it difficult to survive. They've always said that they will soon have to close. Now we're talking about a small trader, an individual. We may have supermarkets nowadays are selling vegetables and barbecued pork, etc. Now, say for example, if someone would like to invoke the CO, would like to take the matter to the tribunal, can this person just fill out a form? Or does it mean that he has to go through many steps, go to the commission for a complaint first in the first place? Now, if you get a lawyer, it will cost you $200,000. So can this person or this trader just fill out a form and do it? Now, for Leung Kwok Hong's case, I think he is saying that the two rules are related. Now, let me cite this example. Can I simply invoke the CO in relation to the second conduct rule? Can this be done?
I should point out is that the mere fact that small traders can't survive does not mean that there's any anti-competitive behaviour anywhere. It may just be that they don't have the economies of scale, or they're simply not efficient enough at what they do to be able to compete with larger players. It may simply be that supply of food through supermarkets is the most efficient way to do it. It's a common complaint around the world that supermarkets drive small businesses to the wall. From a purely economic point of view, we don't know that that's necessarily a bad thing.
Yeah, I know. Now, that is a matter of assessment. But as I say, if the objective observation seems that the price set is really threatened survival, unless you always have a huge amount of resources to put into this kind of underpricing exercise. There are other people who would like to enter into the same market or to survive.
Well, nobody's promised a business opportunity. Either you can compete or you can't. And leaving aside overriding policy considerations...
Okay. Then we need to come back to Leung Kwok Hong's question, that you must have the first conduct of behavior in order to prove the second, because otherwise you said that this is relative. So we cannot buy something, right, I just say example, I'm not specialized in supermarket, okay? I cannot sell this in 5 cents, but they can. You understand?
Well, if you can't prove collusive pricing, then it is impossible to prove that he is or it is preventing a third party from entering the market. So collusive pricing would be very important. First of all, there is a meeting to set the price for the commodities, whether the price would generate a profit or not. Now, when there is a profit, it means that you have dominant market position. Now, for supermarkets, for the first conduct rule, it means that the prices are so low that you are phasing out your competitors. Now, in this ordinance, unless you say that a person is so silly as to threaten a third party, saying that if you dare to enter the market, I will chop you to death, that would take us to the criminal court.
You wouldn't want proceedings to be taken against anybody without an appropriate investigation and evidence. The Commission has substantial investigative powers. Superficial impressions can be very misleading. The mere fact that somebody is successful does not mean that they are abusing substantial market power.
Yeah, Mr. Grover, actually the question I raised and the answer you gave has driven me to think alike as what Leung Kwok Hong has just said, that unless someone can prove the first conduct of behavior, otherwise it's very difficult to say they have conducted the second group of behavior. However, my question, let's leave this aside. We can continue. But I'm asking, just like if a layman, just an ordinary hawker, as I said, in the wet market, if they really want to go through these steps, can they do so according to your annex form, or do they need to prove, like you say, at least we have to prove it with prima facie evidence to prove the Commission first before we go through this exercise?
Well, that's a matter you need to take up with the Commission.
Okay, they need to go to the Commission and prove the case first.
Not necessarily prove, but provide enough evidence to interest the Commission in taking a further look.
So that means either they have to prove, at least it's prima facie evidence that is belong to the first group of
no, I don't think so,
because
the Commission will, I mean, I can't speak for the Commission, but I would imagine that they would get information from all sorts of sources. There will be many complainants, some of which would agree with each other and some may disagree. They may have other independent sources of information. They may have data. They may have conducted investigations, and your complaint may provide a little piece of the jigsaw which fits into the information they already have. So there will be many different scenarios. We live under the rule of law, and I'm sure we wouldn't want the Commission to be pursuing proceedings against undertakings just on superficial judgment. We would want it to be evidence-based.
So you need the recommendation of the Commission.
Well, the Commission is the only body able to institute proceedings. It has other potential approaches, more informal approaches, but it is the only body which is able to take proceedings in the tribunal.
Okay. 梁國雄議員仲有冇嘢問下？
Leung Kwok Hong, the question is, before we had the CO, of course, collusive pricing would never be against the law, as long as you don't lead on to the second conduct rule being breached. Say, for example, I've got 4 persons in a room, there's a collusion. As long as we haven't got another person being prevented from entering the market, so it is not a breach of the law. Is that the case?
Collusion with an anti-competitive, the irrelevant anti-competitive effect is itself a contravention of the first conduct rule.
Are you saying that even before we have the CO, when there is a collusive pricing, that is 4 persons would decide on the same level of price for a commodity and sell it, it is already against the law?
Speaking, no. Because the competition ordinance has been introduced to address.
It is not against the law currently. So if you understand this point, it means that collusive pricing on its own and before the CO is not an offense. So you need to have the second conduct rule before you can be brought under the first conduct rule.
I don't agree with that.
Okay.
If I may supplement, yes, certainly. Well, the principal ordinance is a matter for the CEDB. Now, the Commission is now in the process of recruiting staff, and has already got the President and Deputy President appointed. If you would like to know how the principal ordinance is to be interpreted and the relationship between the first conduct rule and the second conduct rule, I would advise you to ask the CEDB to explain. I think it is related because you talk about the 4 factors relevant to considering keeping information confidential. Now, I understand that you need to consider a number of points. Furtherance of the Rule 37 or Rule 24, we have the interests of justice. So if it is in line with the interests of justice, then the rest doesn't count. Ms. Zhang. When we talk about the interests of justice, well, the judge must follow the provisions of the principal ordinance. Now, it is said that whether certain information can be kept confidential, then certain things have to be taken into account. Now, sometimes some information has to be kept confidential from certain parties, so he can't depart from the principal ordinance. Mr. Leung Kwok Hong, I think we have allowed interested members a lot of time to follow up. If I may also draw the attention of the judiciary to the following. Video conferencing. Understand that a lot of technical problems have been raised. That is, if a witness is overseas, how we can be sure that he's not subject to interference, and then how we can establish a case, how we can make it cheaper to bring an action. and whether there will be legal aid. I think all such matters are matters of concern to this panel. Just now you referred to the Commission saying that it will hand out leaflets to the public. I don't know whether that will be done or not, but I think this has to be done in the light of what transpired today. I think the public have to understand how to invoke the ordinance. And then you said that Canada, the UK, and the US, Australia, you refer to the experience. Now the tribunal will be hearing the cases. Can you not show us the overseas experience? In particular, those areas that we have referred to today. Now, for the rules of the High Court, I understand that you try to adhere to the RHC as far as possible. I think it's better for you to collect the information so as to enable us to understand the following. That is, if I would like to invoke the CO to make a claim, then it means that I have to read the RHC as well. So if the Commission is to issue a pamphlet or leaflet, please show it to us. We may want to give some comments. And also please elaborate the points in writing. I think today we haven't got time to address the following points, like how a third party can join the action. And then for the Lands Tribunal and the Small Claims Tribunal, I know that for the small claims, both parties would not be given the assistance of a lawyer. But then for the Competition Tribunal, maybe one party is represented but not both. I want to know if it is possible to make comparisons with the small claims as well as the Lands Tribunal, and then we can follow the matter up. I think it is important so as to enable members understand how to invoke the ordinance.
Well, we have only 2 members here today, but we have other members who are not from the legal sector, and they are interested in they have an interest in the competition bill. So maybe Ms. Zhang and Mr. Grover can discuss as to how to address Mr. Leung Kwok Hong's point. I also share his view somewhat, whether it's harder to prove the breach of the second conduct rule. Please give us examples that are easier to understand. We should go to the other item now, but I see that our discussion on the Competition Tribunal is quite keen. So, Mr. Grover, Ms. Zhang, I'd like to follow it up this way. Well, let me briefly respond by this. Now, interpretation of the principal legislation is the judiciary's job, and it is not for us to interpret the principal legislation. I advise Madam Chair to write to the CDB for a paper. Next, we also have publicity work, and after this round of consultation, we will distribute the leaflets to the relevant parties. And as said in the paper, the administration would like the Competition Commission or the tribunal to commence its work. And this draft is quite lengthy. It has 150 pages. And this is part of the legislative process. We still have time to discuss in greater detail with members. So, Madam Chair, if you don't object, if other members don't object, may I suggest that a subcommittee be set up so that at that stage we can give you more details on, for example, how to lower legal costs and other procedural matters. We can give you papers and explain, and also on the participation of third parties. We can go through the provisions one by one, but because, well, in light of the schedule, well, perhaps we can have that discussion at the subcommittee stage. Well, I think this suggestion is good. If nobody objects, right, then we can take this forward. And you may also note the issues raised just now. I still have a lot of questions on my list, several pages, but our discussion for today should stop here on this item. I thank Ms. Zhang and Mr. Grover. Please go back and think about the issues we raised. Thank you. We come to the next item. Item 2 for discussion today. Now we're going to discuss the proposed amendment of the Legal Aid Assessment of Resources and Contributions Regulations CAP 91B and adjustments of the financial eligibility limits of the ordinary and supplementary legal aid schemes. CB bracket 4/493/1415 bracket 04. Yes, would the relevant representatives from the administration please enter? The administration has proposed to amend the legal aid assessment of resources and contributions regulations to adjust the financial eligibility limits of the OLAS and SLAS, and also in accordance with changes of the Consumer Price Index C. And may I invite Deputy Secretary for Home Affairs, Mr. Laurie Low, to walk us through the paper. Mr. Low, please. Thank you, Madam Chair. Oh, in short, the principles of legal aid is that applicants would like to make a claim in the litigation will not be deprived of their chance of taking the case to court because of lack of means, and yet assessment will be made according to their means for certain co-payments to be made by the litigants. And that's under Legal Aid Assessment of Resources and Contributions Regulations. There is a schedule for proposing the level of contribution to be made by litigants. Now, in terms of financial eligibility limits, under OLAS and SLAS, the schedule is set up in a manner, in actual amounts, and the FEL, financial eligibility limits, are adjusted in light of inflation, but there are shortcomings. After increasing the FEL a number of times, for certain items, say for item I in the table in para 12, you can see that it is hard to further adjust the FEL upward because, as you can see, the actual amount is really differs only little with the previous span. And also in para 12, if you look at H and I, you can see, for example, in item H, you can see the range of banding is 47. If you look at I, the percentile or the range of banding is only 1 percentile, because originally the FELs are set according to the designated proportion in actual amounts, and now with the change in percentage but not in actual amount, we've come to this situation. So we've proposed technical amendments to the schedule. We hope that under OLS the FEL will be expressed in percentage rather than the actual amount. Secondly, we'd like to take this opportunity to adjust the banding so that the distribution would be more even, and you may wish to refer to Annex B for our proposal. Also, on the payment of the contribution amount, for the lowest tier, no contribution is necessary. For the second and third lowest band, a contribution of 1,000 and 2,000 respectively are required. And our proposal is this. At present, the contribution amount is set at an actual amount, 1,000 and 2,000. But our proposal is that the lowest two bands will have a contribution expressed in percentage, that is 2 and 2.5%, and that's in Annex B. You can see, according to the statistics in 2013, the change. The percentage of litigants not requiring to make any contribution will increase from 72% to 78%. And on the whole, the percentage for other groups or other bands will also be lowered. So, by way of negative vetting, we'd like to make this amendment. Now, having made the amendment, there will be room for us to further increase the FEL for OLS, and we will move a resolution in LegCo to adjust upward the financial eligibility limit for ordinary legal aid assessment scheme, and we'll also do the same for supplementary. According to the CPIC change between July 2011 and 2012 and 2013, we propose to adjust or increase the FELs by 7.7%. That is to increase the amount from 269,620 to 290,300. The asset limit will also be increased to $1.4519 million, and the proposal or a resolution will be moved in LegCo in the second quarter of 2015. Questions from members? Anyone? Any questions? Mr. Leung Kwok-Hong. A question for the administration. The FELs for those with assets are quite stringent. The middle class complains to me all the time that if they take a case to court, then they may be the consequence may be dire, because if they lose the case, they may stand to lose their assets. Now, I see there is some change to help some people here, but not the middle class. Is there any way to help them, Mr. Low? As said just now, the basic policy of legal aid is this. For those with merits in their case, should they want to take the case to court or take part in the litigation, they will not be deprived of the chance to seek justice due to lack of financial resources. So the legal aid department will look at the facts of the case, will also look at the financial resources of the applicant to see if he or she is eligible. For the so-called sandwiched class or the middle class, they may not have high income, but they have assets which may render them ineligible for legal aid. There are already deductions made in the assessment process based on their needs, and self-owned properties can also be excluded in calculating their assets. So what we're doing now is that we need to ensure that meritorious cases will not be deprived of the chance to seek justice due to lack of means, and at the same time we need to strike a balance to ensure proper use of public resources. Those with sufficient financial resources should not take the resources under legal aid, which may be used to help others in need. So we're talking about this major principle under which balance is to be struck, and we're going to adjust these bands according to inflation, because inflation may eat in the real value of the assets of these people, and without adjustments, these people may become ineligible for legal aid. This may not be the part that we should deal with today, but in fact, we've been trying to work under these principles to strike a balance between the individual's needs and the use of public resources. Well, of course, I understand very well the adjustments that will be linked to the CCPIC change. But let's say somebody in the middle class may have $10 million assets. Now, if he loses in the case, he may lose $5 million. So, because I applied for legal aid before, for various reasons, well, I was told that I had to pay $600,000, but there are people who own more than that.
即係規則啦，譬如嗱，如果你係為
may have certain rules and regulations. You may not be taking a case to court for your own sake. You may want to do it for public interest. So can you not waive the restrictions? And then a digression here. Is it possible to change the legal system so that a lawyer can take the case to court for this person, but he only get paid upon winning the case? Contingency fees. I don't think we can do it today, but I'm sure the next time we have a meeting, we'll talk about the scope of legal aid. Now, 3 more members would like to ask questions. Mr. Ng Sing and N. Jiang would like to ask questions, as well as Albert Ho and myself. So quite unlike what we had last time, we need to hand over the venue at 4:30. So 3 minutes for Q&A in the first round. Mr. Ng Sing. Thank you, Madam Chair. For legal aid, I'm sure when we next have our meeting, we can have more specific discussion. In paragraph 6 here, it says that the director may waive the OLASFEL for applicants in meritorious cases. I think this is necessary, but I'm afraid that members of the public may worry. That is, this may be sort of granted to certain individuals repetitively. Say, for example, we have been told that we have got a legal aid, a frequent legal aid applicant who goes to court frequently. So, would it be fair to allow the same individual to have legal aid all the time and many times? So can we be sure that the director of legal aid is using the discretionary power fairly? Now, we have to pay a professional for the legal aid. Is there any way to monitor the use of discretion by the DLA when appointing or engaging professionals? Well, for human rights cases, indeed, the DLA may waive the FGL for applicants. For the LAD to handle the cases as to whether there are checks and balances, when we consider whether legal aid is to be granted to a particular applicant, well, first of all, we have to follow the relevant provisions, say, for example, the merits of the case as well as the means of the applicant. So that's the legal position. When it comes to the enforcement of the ordinance, there are safeguards to make sure that the LAD will be professionally and independently discharging its functions with the legal aid council overseeing the work of the LAD. And of course, we know that there is an appeal mechanism for legal aid. Therefore, if somebody is aggrieved by the decision about legal aid by the department, then that person may appeal to a registrar of the High Court. So there are checks and balances. There are also safeguards to ensure the independence. Dr. N. Jiang. Thank you, Madam Chair. I want to comment on the case of the middle class. They think it is a headache when they have to go to court. So I just wonder whether we can take a good look of the system of legal aid. We do have the ordinary legal aid scheme and the supplementary legal aid scheme. But then if you have only got $1 million or $2 million in your pocket, once you go to court, it can easily cost you $1 million. And even if they have to pay for 50% of the cost, there is still another 50% to be picked up. But then, of course, it must be a huge grievance before it's willing to cough up half of its savings. I just wonder whether, at our next meeting, the administration can cite more examples for our reference and tell us about the overseas arrangements and experience, so that we can see if there is anything we can learn from other places, so that the citizens of Hong Kong can consider revisions to the scheme to help the middle class. In Hong Kong, if you want to become a bully, it's better for you to have no assets at all. Now, you can be a claimant of torture. Such claimants can JR the administration. They can also seek equal opportunities rights. You can't kick them out, and in fact you have to pay for his legal costs to take our government to court. So I support a review of the scheme, but before that, please give us more information so that we can do our homework. Thank you. Do you need a reply from Mr. Low? You can reserve your questions for next time. Everett Ho. Sorry, speaker is off mic. We need to sort out the arrangements. Regarding the bandwidth for the legal aid system, it is all about a matter of resources and sharing contributions. I think we need to review the system. Say, for example, what about separated couples? Unless they have divorced, their assets will be regarded as a single sum. And then in the case of the estate of a deceased, well, if one of the beneficiary would like to take the matter to the court, then all the assets of all the beneficiaries will be taken into account. As long as just one of the beneficiaries out of 5, say for example, has exceeded the asset test, then this will render the applicant not eligible. But I don't think people can really afford the legal costs. It is not easy to apply for legal aid, and yet for the supplementary scheme for the middle class, a lot of things are not being covered. A lot of categories are not covered. Say, for example, defamation. So, after all, for legal aid for the middle class, I think the scope is very restricted. It's more to do with professional negligence or tort. But other things like breach of contract, the middle class may want to pursue such cases, but then they've exceeded the OLAS, and yet they are not eligible for the supplementary one, then they will be caught in the middle. So understand that the review will be done once every 5 years. Can it not be advanced? And then for the resource rules, please review the matter ASAP. Mr. Low, for the supplementary scheme and for its scope, in November 2012, the scope has been expanded. We're inviting the Legal Aid Department to see whether, or the Legal Aid Council to see if we can further broaden it. Now it's my turn. In the year 2009, I sponsored a motion debate and this about legal aid, in particular the assistance given to the middle class. The middle class is caught in the middle. They cannot assert their right to justice as a result. In paragraph 6, it is said that the Director of Legal Aid may waive the OLAS FEL for applicants in certain cases. I think this has been done. We have come across cases in which university professors couldn't afford the legal costs, and then probably they have invoked the ground of ICCPR so as to take a matter to court concerning discrimination. It is said that the DLA will provide for an extra counsel to give advice as to whether it should be granted or not. Of course, it will be thrown out and then it is a great grievance to the professor. So the professors are not happy, and then they try to find out from which chamber the counsel has come from. Well, the complaint is, who is being engaged to write the expert opinion? Is it fair pay? Is it fair play? Would it be sort of on a rotation system? Or would it be just a few handful of lawyers? Let's not mention the law firms. That is, law firms have also criticized the scheme, saying that the legal aid scheme is such that certain law firms are monopolizing the cases. So let's not talk about the scope. Let's talk about the system, the mechanism. As Mr. Low has said, you can appeal against the decision, but then that would mean that you have to go to the court immediately. Is it possible to have a review other than at the setting of a court? Well, if you don't agree with the advice of a so-called expert, can that be invalidated so that a third party can be engaged, so that the appeal doesn't have to go to the court immediately? Well, for your mechanism, I think even the legal profession has got a lot of adverse comments. For the point made by Ms. N. Zhang, I was with the panel last time, during the last term. I think you can certainly read up what has been discussed in the past. As to what I've just said, in fact, in the legal profession and in the tertiary education sector, a lot of people have lodged complaints with me concerning such matters. So maybe you can address such points next time you come. I think that's the time that we've got today. Thank you, members, for coming to this panel meeting despite having a clash of two meetings. Let me wish you all the best and good health in the year of the goat. Thank you.